Welcome to Think Twice Before Suing Opposing Counsel, Anti-SLAPP Risks and Litigation Strategy. I'm Lori Cripp-Martin, Certified Family Law Specialist and litigator who settles most of her cases. I'm delighted to introduce our speakers today. They are Oren Bitan, Efrat Cogan, and Elaine Cheng. Oren Bitan is a partner in Buchalter's Los Angeles office, and he is co-chair of the Los Angeles Litigation Department, as well as the firm's fiduciary receivers and trustees and cannabis and hemp industry groups. He's a trusted advisor in complex commercial litigation, receiverships, and regulated industries, having first chaired numerous trials and arbitrations, secured multiple eight-figure results, and successfully argued precedent-setting cases before the California Court of Appeal and the Ninth Circuit. Oren is widely recognized for his leadership and achievements by the Los Angeles Times and Los Angeles Business Journal, and he serves in prominent roles with several legal and industry organizations. Efrat Cogan is of counsel at Buchalter and is a certified appellate specialist by the California State Bar of Legal Specialization, with extensive experience handling appeals before a variety of courts in matters involving land use, real estate, probate, sports law, commercial disputes, products liability, and employment law. In addition to her appellate practice, she litigates complex cases including construction and real estate disputes, nuisance and easement claims, governmental and constitutional law matters, class actions, and commercial and copyright litigation, drawing on her experience representing both municipalities and developers. Elaine Cheng is an attorney in the Los Angeles office of Buchalter and is a member of the firm's litigation practice group. She previously served as a summer associate and law clerk at Buchalter and was a production editor and staff editor for the Loyola of Los Angeles International and Comparative Law Review while attending Loyola Law School in Los Angeles. Ms. Cheng brings a diverse professional background that includes intellectual property and technology experience at Baker McKenzie in Hong Kong, as well as prior experience in finance, consulting, and education. And now, let's get started.
Thank you, Lori. I like your necklace. What does it say, by the way?
It says my Hebrew name is Tara. So if I have amnesia and can read Hebrew, I'll remember part of who I am.
I like it very much.
That was my grandmother's name, and mine says my name in Hebrew.
There we go.
Excellent. Well, I'm looking forward to hearing your presentation this morning.
Thank you, Lori. So, I'm very fortunate. You all are very fortunate to have Elaine and Effie here. I was thinking, preparing for today's session, it's an interesting interplay between civility and the new requirements by the state bar for us to attest to promising to be civil, that we have been civil, dovetailing that with suing your opposing counsel. I think probably the program title could have been, think 3 times, 4 times, 5 times before suing your opposing counsel, because most of the time it's going to result in an anti-SLAPP. Certainly are exceptions to it. So thank you all for joining. If you have any questions along the way, feel free to chime in. We can make this as interactive as possible. I guess the participants, you don't have the ability to speak or be seen, but feel free to interrupt along the way. We're happy to make it interactive. And I think it is for those that are not very experienced with anti-SLAPP motions. I wonder if we could do a quick poll, but it's, I think, worth taking a step back and talking about what is an anti-SLAPP motion. SLAPP meaning strategic lawsuit against public participation. An interesting creature of California law that does exist in other states, but is really a California-specific thing that is meant to dispose of such lawsuits that are meant to chill speech at an early stage in the proceedings. There are some interesting, unique aspects to it, including that it is effectively a summary judgment in reverse, as some of the cases call it, because of the manner in which it plays out procedurally. And the fact that it is immediately appealable does provide sort of a tactic that I think is pretty often used to delay adjudication of matters. So you're the defendant, you get sued, you file an anti-SLAPP, you lose, you then immediately appeal it, it stays the case. The scope of the stay is arguable, and you can get into all those things. Does it say the entire matter, just that claim, just that pleading, whatever the case may be? In any event, it does slow things to a halt if you want it to. So, we have done a number of them. It's such a malleable tool that can be used in so many different circumstances. State court, there's, federal court nuances to the ability to do it. But Effie, tell us a little kind of about some of your experiences, some of the unique ways that anti-SLAPP motions can be used and adjudicated.
Great. Oren's correct. California's anti-SLAPP statute, which is located at CCP 425.16, is probably the most stringent anti-SLAPP statute there is in any other state. I've had to address anti-SLAPPs in other states, and none of them are as defendant-friendly as ours is. When the anti-SLAPP statute was first enacted, it was construed very narrowly originally by the courts. They thought that it was only supposed to address the paradigmatic people are out picketing and a developer wants to stop them. Now it applies to all kinds of claims. You don't have to show that it chills speech anymore. All you have to show is that it qualifies under 425.16E. Either conduct occurring in an official proceeding, in a judicial proceeding, in a matter of public interest, and there's case law that explains what each of those things mean. And the beauty of an anti-SLAPP for a defendant is if the plaintiff alleges that conduct is petitioning activity, then it shifts the burden to the plaintiff to show a prima facie case, that they can make out a prima facie case based on actual admissible evidence, not based on the allegations of their complaint. It now applies to defamation claims because by definition, you sue someone for defamation that arises as petitioning activity, especially if it involves a prior lawsuit. Even though, for example, Civil Code Section 47 is not a bar to a malicious prosecution suit, the Supreme Court has said that if someone sues you for malicious prosecution, you can bring an anti-SLAPP. They're going to have to prove a prima facie case at the inception that they can demonstrate a lack of probable cause. In my experience, that Supreme Court case is Jarrow versus LaMarche. Myself, Harry Chamberlain, and Bob Dado were involved in that case. Since that case was decided, and it was decided at the Supreme Court, no one agreed with us till we got there. I have never seen a malicious prosecution case prevail against an anti-SLAPP because plaintiffs are never prepared to address prong 2. It applies when a lawyer represents a client and gets on television and accurately describes the allegations of the complaint. There are cases where lawyers get sued for that. And the courts have said, no, if you're on the news describing the allegations of your case, you're good. And the other beauty of an anti-SLAPP is if a plaintiff is thinking lazily about the allegations of their complaint, and they're not thinking about whether something falls within one of the prongs of the anti-SLAPP, they've given you, as a defendant, a basis for bringing the anti-SLAPP, and the consequences to them are huge. If you as the defendant win, you get your attorney's fees, all of them. If you entirely win, some of them if you partially win. If you're a plaintiff and you're lazy and you think that you can just bury protected activity in a cause of action where the cause of action might otherwise, you think, survive, you're still going to lose, because the Supreme Court in Beryl versus Schnitt has now said an anti-SLAPP motion goes to allegations in a complaint, not just to the cause of action. I was involved in just such a case as that. It's the Crossroads case, Crossroads versus Fannie Mae. And there was, the case was a mortgage foreclosure case, which you wouldn't think would be subject to an anti-SLAPP motion, but they alleged in their complaint that our wrongful conduct was failing to provide them with the amount it would be required to, what's the word I'm looking for, Oren?
Tender?
Yes, to tender in order to cure the deficiency. But what they left out was that they never asked for it, and the only place they asked for it was in a discovery response in bankruptcy proceedings. And as it turned out, the trial court disagreed with me and the Court of Appeal disagreed with me, and then we went up to the Supreme Court, and the Supreme Court remanded at the same time that it remanded Beryl versus Schnitt back, and then the Court of Appeal said, yeah, you're right, these allegations go. And it significantly narrowed the case.
Well, I think technically the trial court disagreed with me.
Oh,
and the
yes.
Court of Appeal disagreed with me. And then Effie got involved and the Supreme Court agreed with us. So
there you
perhaps
go.
There's a moral of the story there.
Always call me. I'm kidding.
And so in that case, these things can arise not necessarily from a claim against a lawyer, but a claim against a party for the acts of a lawyer.
Yes.
So it can go either way in that sense, trying to hold a party liable for what the attorney did within the context of a proceeding. And the overlap with Civil Code Section 47 is very powerful in the context of an anti-SLAPP, the litigation privilege. So it can be pre-litigation, it can be during litigation. It is broadly interpreted to protect acts taken within the context of a dispute.
Yeah, now there is case law in the anti-SLAPP context that says Flatley versus Morrow is the case that's most cited for this, that if conduct is unlawful as a matter of law, it will not fall within prong one. In Flatley versus Morrow, it was a letter by an attorney that all the parties agreed was on its face extortionate. The court refused to provide anti-SLAPP protection to that. But rarely is conduct considered illegal as a matter of law, as it was in that case. And B, there's case law that says that where there's a dispute as to whether the petitioning activity was lawful or not, and that's the vast majority of cases, Whether or not it was wrongful is not decided on prong one. You get the benefit of the prong one. We're not sure if it's legal, if it's illegal, it's petitioning activity. We're moving on to prong two. And then at prong two, the plaintiff has to prove that the action was wrongful in order to be able to move forward. Should we talk a little bit about how it's different in federal court?
Yes.
Do you think? Federal court, in state court, you bring an anti-SLAPP, discovery is stayed on all claims affected by the causes of action to which you're bringing the anti-SLAPP. So essentially the plaintiff's case stops. When the court rules on the anti-SLAPP, that's an immediately appealable order. In most circumstances, it's going to affect a stay of the entire case. In federal court, it's different. Federal courts don't like anti-SLAPPs that much. In the Ninth Circuit, they recognize that an anti-SLAPP, even though it is also procedural, it has substantive aspects, which means that it is to be applied in the federal courts. But there's a huge but. It does not stay discovery because that's entirely procedural. The 60-day time limit for bringing an anti-SLAPP does not apply, meaning that you can wait. You can allow discovery to go on and you can bring it as a summary judgment motion later. And whether it is granted or denied, it is not a separately appealable order. It doesn't have the same power in federal court as it does in state court, unless it happens to be what I like to call paradigmatic anti-SLAPP motion. Someone sues you for issuing a cease and desist letter immediately prior to litigation. Someone sues you for filing a lawsuit against them. Those, even in federal court, are easily disposed of at an early stage. The last thing I would say, as a reminder to everyone, and it'll tie into our discussion of the court's new case, is plaintiffs often think that that they can artfully plead around an anti-SLAPP. And you really can't, because most anti-SLAPP motions are accompanied by evidence. So a plaintiff can try to plead around an anti-SLAPP, but if you, as the defendant and the defendant's counsel, know that really the basis of this is petitioning activity, you are entitled, and you should, on an anti-SLAPP motion, make it an evidentiary motion. Attach declarations, attach pleadings, prove to the court that you've met prong one. It's 2/3 of the battle. And I would always suggest that you do that.
And if you don't get past prong one, the court doesn't even go to prong two on the merits. So that's sometimes an easy way for a court to not have to deal with all the facts and the evidence and just simply find that it doesn't arise from protected activity. Therefore, you don't meet prong one, you never get to prong two. And sometimes when cases go up and down, the Court of Appeal will send it back down for the trial court to then go to find in the affirmative on prong one, deal with prong two, and you still lose. So there's that interplay. The only thing I'd say about federal court too is there's been a lot of debate, right?
Yes.
In the federal courts, is this procedural? Is this substantive? Are you sort of circumventing Rule 56 on summary judgment motions? Does this really belong here? And to Effie's point, federal courts don't really like them, I think, for that reason. So let's turn it over to Elaine, who will tell us about the latest case in this area. And I guess my final point, this can apply to so many things. Effie described a case we had with discovery responses. I've had a case where a lawyer hired a PR company and issued a press release that had false statements in it. So it can be quite broad as far as the acts of your opposing counsel. So Elaine, tell us about the latest developments in the case law.
So the latest case that inspired this article and this presentation is Ramirez versus McCormack, the latest entry in a growing line of cases that addresses a recurring phenomenon that both Oren and Effie have spoken about. Dissatisfied litigants that sue counsel for conducts that occurred during or after an underlying case. And in that sense, this case, Ramirez versus McCormack, really isn't an outlier, but the newest reaffirmation of a principle in California courts have repeatedly emphasized, that the adversarial system protects lawyers from liabilities for doing their job. I'll turn first to a general background of the facts of the case. So Adriana Ramirez was a property manager at the Stockdale Villa Mobile Home Park. After she was terminated, she sued her employer Stockdale and a third party, Harvey Miller, who was the owner of Stockdale, on employment claims. Miller hired attorney Sandra McCormack, the main character of this case, to bring an unlawful detainer action against Ramirez. The parties eventually reached a settlement agreement that resolved the employment and unlawful detainer action. And along with some other terms, the agreement required the dismissal and sealing of the unlawful detainer action and payment of settlement funds to Ramirez through her attorney, McCormack. Ramirez was unhappy with McCormack's representation of Miller and sued McCormack, claiming a number of things: that McCormack had delayed or refused to seal the unlawful detainer action or records, which would have impacted her ability as a property manager to get subsequent employment, that she sent settlement checks to the wrong address, and overall interfered with the execution of a written settlement agreement. Unsurprisingly, McCormack moved to strike the complaint under the Anti-SLAPP statute, arguing that all of the alleged conduct in the complaint arose out of her representation of her client in the underlying litigation, all of which were protected petitioning activity under the statute. Relying on Thayer versus Capitect, which actually is a case that Buchalter assisted with, McCormack invoked the well-established precedent that communications, negotiations, and filings by attorneys in the course of representing clients are shielded from liability and fall squarely in prong one of what the anti-SLAPP is designed to protect. So Ramirez opposed McCormack's anti-SLAPP motion and hinged her opposition on the idea that the Thayer versus Capitect case didn't apply because McCormack's alleged conduct occurred after Ramirez had already dismissed her lawsuit. Ramirez reasoned that because her dismissal effectively concluded the lawsuit, McCormack's alleged conduct fell outside the scope of Thayer and the anti-SLAPP statute. The trial court agreed with Ramirez and effectively drew an artificial line after settlement. The trial court relied on two cases, but neither of those two cases involved lawsuits against opposing parties' attorneys, or any attorneys for that matter. So in effect, the trial court took the position that once a settlement agreement is signed, conduct is no longer protected by the anti-SLAPP statute. The good news for all of us is that the Court of Appeal disagreed, and in coming to that conclusion, the Court of Appeal walks through the Thayer case itself. So in Thayer and his spouse were potential beneficiaries, and maybe Effie can go into a little bit more.
You do it. It's good.
Okay, Thayer and his spouse were potential beneficiaries of a class action that was prosecuted by the Capitect law firm. Thayer had wanted more money, accused Capitect of mismanaging the settlement allocation, and the firm responded by an anti-SLAPP motion, arguing that the lawsuit attacked its litigation conduct. Court of Appeal there agreed with Capitec. And in line with that case, this Court of Appeal for Ramirez versus McCormack found that the Ramirez complaint alleged liability that directly implicated petitioning activity. The court specifically writes that this includes things like directing process servers, communicating with other counsel, negotiating and drafting a settlement agreement, advising clients whether and when to perform according to the terms of the settlement, and drafting requests to dismiss and to seal the unlawful detainer action. So basically, everything that McCormack was doing and everything that Ramirez was alleging McCormack was doing was done to help her client petition.
Can I interrupt a second? It's worthwhile noting that all of the things that the lawyer was described as doing involved kind of processes of litigation. It's been the law in California for a really long time that claims for abuse of process are slappable because they involve petitioning activity, because the anti-SLAPP statute doesn't just protect conduct that occurs inside a courtroom. It protects everything that has a logical connection or relation to the litigation. Certainly, settling the claim and taking actions necessary to effect it are subject to the anti-SLAPP. Go ahead.
The Court of Appeal rejected Ramirez and the trial court's distinction that Ramirez was only challenging post-settlement actions for two main reasons. First, that Ramirez's complaint makes factual allegations rooted to times and actions before any settlement was even contemplated or achieved, and that obviously with this litigation between Ramirez and the opposing party's counsel, that the litigation between the two sides is clearly not over. So through the combined force of Thayer's precedent and the policies of the anti-SLAPP statute, the Court of Appeal protected a lawyer's ability to do what's necessary in furtherance of the right of petition. And based on this, the Court of Appeal held that McCormack successfully met prong one of the anti-SLAPP statute. It is important to note that in this case, it echoes the anti-SLAPP statute in the sense that even if a defendant establishes its conduct constitutes petitioning activity, a plaintiff could still make a prima facie case of prong two. But here, Ramirez simply didn't do that. Ramirez's opposition relied a lot on argumentative declarations from counsel without any admissible evidence of wrongdoing or a showing of damages, and expressly declined to brief prong two, stating that she would only brief prong two if the court ruled against her on prong one. So what does this really all mean for us as litigators? Ramirez confirms that attorneys have broad statutory protection for conduct arising out of their professional duties. This includes settlement communications, post-resolution actions, everything that Effie and Oren had spoken about earlier. The court treated drafting dismissal papers, coordinating sealing, everything as advocacy, and that advocacy is protected. So secondly, anti-SLAPP remains a powerful early defense tool if you're accused of interference the way that McCormack was based on litigation conduct. This case reinforces that you definitely should consider moving to strike under the anti-SLAPP statute. And third, and probably most importantly, if you're doing this on behalf of someone, don't skip analysis on prong two. The anti-SLAPP analysis is two-pronged, and if you fail to address one prong effectively, you waive it. Unaddressed issues are deemed forfeited, and requests for supplemental briefing won't necessarily save you. So that's the takeaway from Ramirez versus McCormack.
And I think it is important, the court noted just because a claim arises from protected activity doesn't mean the anti-SLAPP's automatically granted. You know, if you get to prong 2 and the plaintiff is able to prove its case that it has a likelihood of prevailing on the merits, you'll survive. And so I had a case where a claim against, lawyer hiring a PR firm, issuing a press release post-trial, but the allegation was the press release had false statements in it. And so, sure, the attorney's hiring of a PR company and issuing a press release relates to the matter. It's protected activity. But once you get to prong 2, we were able to prove there are false statements there, and we have a likelihood of prevailing. So anti-SLAPP denied.
There's a gloss to that, and I'm glad that Oren brought up that case because it is true that if a complaint addresses communications that are made in court or pre-litigation or regarding settlement as between parties, that's going to fall within 47B. And while I never suggest that anyone shouldn't address prong 2, they should, the likelihood is that if your prong 1 analysis is shows that you can claim the absolute litigation privilege, no prong 2 analysis is going to help you. In the case of, for example, a press release issued to the press, right? That's not going to be subject to 47B. That's going to be subject to 47D, that privilege, which is a qualified privilege, which means that it is really important to have a prong 2 analysis because you're not fighting against an absolute privilege. You're fighting against a qualified privilege. So you want to show, as Oren successfully did, that you fall outside the qualified privilege. The other thing I think that Ramirez teaches, and I tell this to people all the time, is that when you submit evidence on behalf of prong 1, make sure it's admissible evidence. And when the other side submits evidence purportedly in support of prong 2, or vice versa if your roles are reversed, make sure your evidence is admissible, and each side should actually look at the declarations and make evidentiary objections. Judges, at least in the LA Superior Court, will rule on those evidentiary objections if you make them. And if you don't make them and then you lose, you forfeited the objection.
Don't want to do that.
No, I tell people all the time, don't do that because it makes it harder on appeal.
So we had one question. What was the site for the mortgage case and where can I find the handout? We don't have handouts, but we're happy to give you that site if you want to email one of us or all of us online.
Yeah, email us and we'll send you the site. It's a published case. It's called Crossroads versus Fannie Mae.
Another question, do pro-per litigants get a pass because they are non-lawyers, even after they're repeatedly told in writing to drop their suit?
No.
I think that's a no.
They don't get a pass. In the old days, I like to joke, back when dinosaurs roamed the face of the planet, we used to...
You're that old?
Yeah, I'm that old. We used to actually meet and confer before we filed an anti-SLAPP to make it look like we were reasonable and the other side wasn't. Yep. You don't have to meet and confer with the other side. There is no requirement. You simply bring your anti-SLAPP motion. If you win your anti-SLAPP motion, you can ask for attorney's fees. As an aside, some people ask for their attorney's fees in their motion. I generally don't. I wait to bring a follow-on motion in the event that I win. Number one, because I can't calculate all of my attorney's fees till I'm done with the reply and with oral argument. The only problem you might have with a pro per is that are they judgment proof with respect to the attorney's fees? And sometimes anti-SLAPPs can be expensive, especially if there's a lot of evidence involved. In which case, is a judge really going to want to give you all of the attorney's fees that you're actually owed? Or do you just want to tell the court how much money you actually spent, but ask for a lesser amount to seem reasonable? But those are questions you have with your client. But no, they're not excused.
Yeah, they're still bound by all the same rules. So I don't think there's discretion to deny the anti-SLAPP because it's a pro per, but maybe discretion to lower the attorney's fees. That's not really a great grounds either, just because it's a pro per or some person who can't afford it.
And note, the successful defendant on an anti-SLAPP is entitled to their reasonable attorney's fees. The statute says shall. The court shall award. A successful plaintiff is not entitled to their attorney's fees unless the court finds that the anti-SLAPP motion was essentially frivolous or harassing as defined by CCP 128.7, the equivalent of, the federal court Rule 11 standard. The interesting question, which we can't answer on that score, is the statute provided for that before there was a safe harbor provision to 128.7. I don't know how, I'm not quite sure how under the anti-SLAPP you as a successful plaintiff bring a motion for fees for a frivolous anti-SLAPP when you couldn't safe harbor it. But that's a question for the court for another day.
And I have, when opposing an anti-SLAPP, have requested a finding by the trial court that it is a frivolous motion. I'm not sure any judge took me up on that request, but that certainly shortcuts the path to fee recovery for a successful plaintiff defeating an anti-SLAPP. On the meet and confer, it's one of our senior partners here, I think his practice is to send a letter before the anti-SLAPP is filed. So I guess going back to general tenets of civility and giving the benefit of the doubt that perhaps the opposing lawyer hasn't flagged the issue and is willing to reasonably consider our position. I guess the only downside there is after you file an anti-SLAPP, the pleading cannot be amended. It is then frozen until the anti-SLAPP is ruled on. Whereas if you send a meet and confer letter, they can, I suppose, try to amend, hopefully amend to remove the offensive claim or allegation. But perhaps the more cynical view is try and artfully plead around the anti-SLAPP somehow. So those are the tenets there. But yeah, once you file the anti-SLAPP, they cannot amend. So even if it's their first, the initial complaint, anti-SLAPP filed, there's no right to amend to get around it.
And by the way, an anti-SLAPP ruling is not like a ruling on a demur. It's not, sustained with leave to amend. if it's granted, that claim or those allegations are gone. They're stricken from the action. Are there other questions?
Speaking of attorney's fees, attorneys can't make anti-SLAPP motions in pro per and get their attorney's fees. Must they obtain outside counsel?
I don't.
It's an interesting question.
I seem to recall that there was a dispute years ago. There was a conflict in the courts about whether attorney's fees in pro per could get their attorney's fees. And I thought, but this is a while ago and I haven't shepherdized, so this is not
We're not providing
advice.
any legal advice here.
We're not providing legal advice.
All right, we're getting lots of legal advice questions.
Yeah,
all right?
but
we're not going to be doing that.
No, but I think I'll suggest this. Look at a Supreme Court case called Trope versus Katz and shepherdize it. I think that an attorney might be able to get their attorney's fees, but it depends on what the current state of the law is following Trope versus Katz. That's TROPE versus Katz, KATZ. And that was not a legal opinion or advice.
So another question. Where a lawyer sends a letter containing false statements that's intended to and does induce the recipient to terminate a contract, will a suit against the lawyer and or his client be subject to an anti-SLAPP?
The answer is it depends.
Yeah, definitely depends.
It depends on the letter. It depends on the law, and it depends on how much evidence you can adduce and whether you might draw an anti-SLAPP.
Right.
You might draw an anti-SLAPP, and you would have to keep in mind the fact that there is case law that says that it's hard to establish the reliance prong of a fraud claim when you're relying on opposing counsel's statements. It might not be reasonable to rely. So you might have, even if there's a prong issue and there's a prong 1 issue and a prong 2 issue.
Yeah, and remember the interplay of prong 1 and 2. So even if it arises from protected conduct doesn't necessarily mean they're going to win their claim. They're going to be able to show a probability of prevailing on the merits. So,
you know, it's my personal view, and I know I'm a lawyer and most people here are lawyers, and I'm not saying this just because I'm a lawyer, but it's generally a pretty unsafe practice to sue opposing counsel. If you have a dispute, your dispute is with the opposing party. It's not with their counsel. And why risk an adverse ruling in attorney's fees that you then have to pay the party that you're suing so that they have more money either to defend or to countersue?
yep, agree. Can you get a multiplier for attorney's fees on a successful anti-SLAPP?
Technically, you might. I'm not sure. In my practice, I'm not sure I ever asked for one. And I don't recall a reported instance of that occurring. But if you're going to ask for a multiplier, you're going to have to, follow the rules set out in is it the Ketchum case, for determining whether a multiplier is appropriate.
I've never asked for a multiplier. Let's see.
just give us a second. Some of these questions are long.
This one's more of a comment. I'll skip that. This is a long one. All right. I want to hear what you have to say about malicious prosecution suits after a final adjudication. Attorney was sued by defendant employer for prosecuting a claim on behalf of plaintiff employee. The employer's suit was slapped with an award of fees and costs to the plaintiff's attorney, affirmed on appeal. Employer files BK. Why cannot a malicious prosecution case against the attorney who filed the slapped suit proceed?
I think the factual scenario has gotten me a little bit confused. But I will just say this about malicious prosecution. You should read Jarrow versus LaMarche. It's a Supreme Court case. I don't have the site on hand. You can bring a malicious prosecution action, okay? But malicious prosecution, the act that is causing the malicious prosecution lawsuit is, by definition, petitioning activity. Someone filed something in court, correct? They filed something in court. That satisfies prong one, okay? A malicious prosecution action does not have the benefit of Civil Code 47 as an absolute privilege, so there needs to be a prong two analysis. You need to demonstrate at the inception of the case that you can prove the elements of malicious prosecution, right? That the action was not brought in good faith and that it was brought with spite, malice, or ill will, and the prong that will usually defeat a malicious prosecution action, that it was brought without probable cause, right? You always need to prove that to prevail on malicious prosecution. If you can't do it at the inception, then the malicious prosecution action is going to be slapped. That's just what's going to happen. It's what happened in Jarrow.
Malicious prosecution actions are very difficult to prosecute, heavily disfavored. We have kind of a testy bunch here, ready to sue everyone for malicious prosecution.
Or else they're already doing it.
This topic is counseling you to take the high road. All right? Don't sue your opposing counsel. This is the takeaway here, people. Don't overextend the bleeding with a malicious prosecution action. You're setting yourself up for an anti-SLAPP every time, I think. On a malicious prosecution, on an abusive process claim, it's like you're painting a bullseye on your forehead. And then you're just gonna litigate that and then go up to the Court of Appeal and litigate there, and enough already. Enough. State Bar is counseling us to be civil. Right, Effie?
Yes. It's
we can be zealous advocates and still preserve the tenets of civility. Right?
Yes. You also tend not to make friends with the other side when you sue them.
It's fair.
And I will tell you that oftentimes when a defense lawyer gets sued by the other side for something that is clearly slappable, the first instinct is they're mad and they're affronted, and their second instinct is, oh, I'm going to get all of this money. This isn't going to cost me a cent. There's just no point to suing opposing counsel. There really isn't. Rare is the case take Flatley versus Morrow as an example where you'll get away with it. And if you look at Flatley versus Morrow and you read the letter that the attorney sent, you'll understand why that's the exception to the rule. It requires such flagrant conduct that is pellucidly and clearly illegal for an attorney to fall outside of the protection of the anti-SLAPP statute.
Extortion,
Yes,
right?
the letter in Flatley was an extortion letter. It was, in effect, look, our clients have a dispute and this is what I want you to do. And if you're not going to do it, then I'm going to go to the press and I'm going to tell them all kinds of private facts about, you know, your client's life and ruin them.
Right. Threatening criminal prosecution if you don't do A, B, and C.
Correct.
Flagrantly false statements that just have no basis in fact.
Well, not always. Rubin versus Green.
That's a squishier.
My reference to Rubin versus Green is to a California Supreme Court case that says that in court, lawyers are protected even if they commit perjury. So, you know, that's different than writing an extortionate demand letter, but I'm just saying.
Would the same be true in a malicious prosecution action for continuing to litigate after filing where deposition evidence confirms there's no basis to continue to litigate?
Yes, the same is true. You might have a better shot. I think you're thinking about Zombos. You might have a better shot of demonstrating a lack of probable cause because you have more evidence, but you'll still be the recipient of an anti-SLAPP, and malicious prosecutions are still disfavored in the law.
Agree. Well, we have a few minutes left. Effie or Elaine? How about Elaine? Some final thoughts?
Go ahead.
Words of wisdom for the fine members of the Beverly Hills Bar Association.
I feel like anything I have to say would be off the backs of the two of you.
That's fine. That's acceptable.
I mean, I'm pretty new to anti-SLAPP, but from reading the case, I feel like I would just steer clear of the potential of being slapped because if I feel like it just doesn't lead to a good result, especially if you risk losing and having to pay for attorney's fees.
You know, defendants have, especially lawyers who are sued as defendants, have a high incentive if there's a basis for bringing an anti-SLAPP. In the case of a lawyer, there almost always is. They are highly incentivized to bring the anti-SLAPP. Sometimes plaintiffs are so angry at the other side that they want to throw everything in a complaint. In my view, it's our job as lawyers to manage the client's expectations and to explain to them the risks, because at some point, a plaintiff who's suing on something that is slappable ends up surprised and upset that they've not only lost, but now they have to pay a lot of fees. So bringing an anti-SLAPP is far less risk for a defendant and far more risk for a plaintiff. You should think about it a lot before you do it.
Wise advice, and I agree. It's our job. We have angry clients who are passionate to tamp down, to filter all of that into something that's really a viable claim. Yeah, we can't be suing lawyers for everything they do, and it's our job to really filter it. And I agree, you'll get a disgruntled client at the end of it, and you're not going to be happy with the result, and it's just going to slow down the process of getting to the merits on whatever the underlying dispute is, which is what we all want. So I think cautionary tale here on claims against your opposing lawyers. One final question. Thank you. Thank you for that. This is the actual heart of the matter, and I'm grateful that you closed with this. Client control is our paramount duty. Amen to that. So thank you. Absent any final questions. Oh, we have one more actually. Oh, more of a comment. Okay. So thank you everyone out there for joining us. If you have any additional questions, feel free to email any of us. Effie's the smartest one. I'm happy to send you any. Someone asked about a case I worked on offline. If you want to shoot me an email, I'm happy to talk about that. But thanks so much for joining us. Thanks for the Beverly Hills Bar for hosting. And Elaine, in her debut CLE performance, didn't she do a great job, everybody?
Thanks.
Virtually clap.
Co-author of an article in the Daily Journal, and now co-presenter at a CLE for the first time. So thanks for keeping us company. All right, everybody, have a good day.
Bye all.